and thank and this honorable court. This honorable court now in session, please be seated and come to order.
Thank you. Good morning. Welcome everyone to the DC Court of Appeals. We have one case on the regular calendar today. Irvin Harrison Johnson versus United States. The lead case number is 13 CF 493. Will counsel for Mr. Johnson go ahead and approach, and please let us know how much time you would like to save for rebuttal.
Yes, Your Honor. I'd like to reserve 3 minutes for rebuttal. I'm removing my mask if that's okay with the
Yes.
court. May it please the court. My name is Morgan Branch, and I'll be arguing on behalf of appellant Mr. Irvin Johnson. Mr. Johnson is currently serving an 86-year sentence based primarily on 4 pieces of evidence introduced at his criminal trial. Now, as we've outlined in our briefs, it's our position that each of these 4 pieces of evidence were tainted by constitutional violations, but I want to focus my limited time today on 2 of the more critical errors, both of which relate to alleged confessions, a category of evidence like no other that can be admitted against a criminal defendant. Now, I'd like to start with the legal note that was blown up in front of the jury at trial and characterized by the prosecution as a confession. Both trial counsel, through ineffective assistance, and the government through intrusion, violated Mr. Johnson's constitutional rights.
Let me ask you the ultimate question in my mind. So what? This isn't much of a note. I think the government was really stretching to refer to it as a confession. And as I read the record, defense counsel didn't even bother to respond in closing argument. So where's the harm?
Sure, Your Honor. And it's our position that there was certainly serious prejudice that stemmed from use of the note at trial. And dispositively, the government doesn't even dispute that there was prejudice in their briefing to this court. Now, I think another piece of this is the fact that trial counsel herself admitted that she was taken aback when the note was introduced at trial.
But let's stick with the so what. If you could refer to the note itself and what portions of that note harmed your client?
Well, I think first and foremost, it was the fact that the government painted it as a reference in the first person. And I think that, as trial counsel testified, was quite damning during trial. And so I think that aspect of the note was certainly prejudicial. I think also the fact that the government said, these are Mr. Johnson's words, this is him confessing to the crimes at issue. I think that's the so what. I think that the so what is that the jury takeaway from that was that, in his own words, this defendant confessed to the crimes at issue.
But how do you square that with, I think, 2 salient facts? One is that the note speaks in almost sort of hypotheticals, right? If it were me, then how would they know if I was wearing the hat and glasses? And that to me seems like something that an innocent person could also be saying. And so it doesn't rise to me immediately as sort of a confession of like, I did this, how am I going to get out of it? And then secondly, I know we interrupted you as you were saying that defense counsel was sort of taken aback when the note went up, but defense counsel had the opportunity to address this in closing, and I understand declined to.
Yes, Your Honor. And I think part of that was that she was taken aback. She was surprised. She wasn't anticipating the fact that the note would be painted as it was by the government. To your first question, I think that you can't really decouple the note from how the prosecution presented it. So, in looking at the note, certainly, and thinking about Mr. Johnson's intent behind writing it, certainly it can be quite damning. But it's the way the government used it at trial that really, I think, put the fine point on the prejudice that stemmed from its use. And, I think the closing argument in general is illustrative. The government spent a significant portion of their closing argument focused on the note, blowing it up in front of the jury and calling it a confession. I think just the mere fact that the government found it so important to their case that it was central to their closing argument is also supporting the record certainly for its prejudice.
And does that overcome the other significant evidence in the case? I mean, I know you have sort of a cumulative error argument, but putting
Sure.
that to one side, if we are looking at all of the other evidence in this case, why is this so prejudicial?
I think first and foremost, and, I think many courts, including this court, recognize that confessions is very powerful evidence in a criminal case. And so, I think that that's part of it, certainly. In terms of collective prejudice and cumulative prejudice, I think some pieces of evidence are certainly more prejudicial than others, but having all four tainted by constitutional violations, all four pieces of evidence that really were the only four pieces of evidence that are in the record at his criminal trial that even came close to connecting Mr. Johnson to these crimes. I certainly think that when you have these serious problems with all four pieces of evidence, it cumulatively prejudiced his trial. Now,
So
Sure.
far, counsel, we've been assuming that this note is protected by the Sixth Amendment.
Sure.
But the trial court made some findings after hearing testimony, and those findings tend to blow your Sixth Amendment claim out of the water. She's saying, if there was a note protected by the Sixth Amendment, this is not it. And this particular note was not protected by the Sixth Amendment because it was not written as a prelude to consulting with his lawyers.
Sure. And Your Honor, I think that there are three paths to finding that the note was protected either under work product or as an attorney-client communication. And at this point, this court need not disrupt the trial court's findings of fact for two of those paths to find that the note was protected. So in terms of the work product argument, that's straightforward. The note was protected as a matter of law, even under the trial court's own findings of fact, because it was prepared by Mr. Johnson as part of his investigation into his defense. Now, the error—
You use the term straightforward, so I'll need you to show me that straight path.
Sure.
I had never understood the work product doctrine to be that broad and to apply to any note that a defendant might write to himself without urging by counsel before his trial takes place.
So, Your Honor, and it's not our position that every single piece of writing that a defendant creates is protected by work product. But in this case, what you have is you have a defendant who's recently indicted, reading over the affidavit for his arrest warrant. He had just attended the preliminary hearing, and he's jotting down notes that are very important to his defense that he later subsequently discussed with his defense counsel. And so in terms of and sticking to work product, I think the error was where the trial court found that there needs to be an explicit instruction or a defendant needs to be directed explicitly by his trial counsel to write a note in order for it to be protected. And it's our position that the law does not require it. So
maybe the label is misleading, but over the years, we've called this the attorney work product. You seem to be turning it into the defendant work product privilege.
Your Honor, it's our position that the work product doctrine doesn't only protect documents created by attorneys. The work product doctrine, it's our position, also protects documents that are created by the defendant. And there's support for that. You have, and we've outlined this in our brief, but Rule 16 of the Criminal Code explicitly protects documents made by defendants.
So
And
follow up on that. So I take your point on Rule 16(2)(a), but you said just a few minutes ago that you don't think the work product doctrine covers kind of anything that a defendant makes. And I'm wondering, how do you sort of square that with the really capacious language of the rule, which does not authorize discovery or inspection of reports, memoranda, or other documents made by the defendant? So I know that's sort of a textual question about the rule, but then also, where do you draw the line to the extent there's a line to be drawn?
Sure. And I think that where you draw the line is where the defendant is creating a document that's specifically designed to assist with his defense investigation, to contemplate strategy for, his trial. And I think that's squarely what occurred in this case. Mr. Johnson, understanding there's a dispute on the facts, Mr. Johnson created this note specifically, intending to discuss the contents with his trial lawyer, and ultimately he did. Even the trial court in her findings of fact acknowledged that all of the subject matter that appeared in Mr. Johnson's note was ultimately discussed with his counsel. And if you were to find that the document itself if you remove the privilege from the document itself, then in essence, you're removing the privilege from the subsequent conversation, and that cannot be how the law operates.
Well, counsel, let me ask you too. So if Mr. Johnson were not incarcerated at the time or in a cell, like he wouldn't have been subject to these regular kind of searches. If we didn't allow the privilege there, would that prejudice someone in his situation as compared to someone on the outside who was preparing for their case?
I think the rule would equally apply to someone on the outside. But I will say, as one distinguishing factor when you're thinking about whether it's protected for an incarcerated individual, and as we all know, people who are sitting in the DC jail awaiting trial have very little control of when they get to talk to their lawyers. They have to wait to be contacted. They have to wait for a visit to be scheduled. And sometimes that's very difficult. The chilling effect that it would have on defendants sitting in jail, awaiting trial, and their communication with their lawyers to find that notes that they've jotted down to discuss with their lawyers at a later date wasn't protected by the attorney-client privilege or the work product doctrine, I think that would be quite problematic. Now, finally, as to Mr. Johnson's intrusion claim, because the note, it's our position that the note is privileged under either the work product doctrine or attorney-client privilege doctrine, and because the taint team indisputably shared the note with the prosecution in this case, that is a per se violation under United States v. Neal. And unless there's any other questions on the legal note, I'll move on to the next issue.
Please go ahead.
Now, the second purported confession that was presented to the jury at Mr. Johnson's trial was the testimony of Mr. Curtis Faison. Now, Mr. Faison told the jury that Mr. Johnson confessed to the shootings at issue through the toilet pipes at the DC jail. The problem is there was a cache of impeachment evidence that was not turned over by the government to Mr. Johnson's defense counsel. The government does not dispute that the impeachment material was favorable. And so the only dispute with respect to Mr. Faison's impeachment material is whether it was material to the outcome of Mr. Johnson's trial. And it's our position that under the two-step analysis in Vaughn v. US, this court's decision, it certainly was material. Now, first, as to Mr. Faison's role in the government's case, he was critical. This was a confession in a circumstantial evidence case, and the government itself called his testimony admittedly important.
And so sorry,
Sure.
Are you focusing here on the mental health records or on the history of cooperation or both?
Both. So starting with the mental health records, which goes to sort of the second prong of the Vaughn analysis, which is the nature of the withheld evidence. The withheld impeachment material goes directly to the truthfulness of Mr. Faison's testimony. Now, the court in Vaughn confirmed that sometimes impeachment evidence is the most powerful Brady evidence to be withheld. Now, if you line up Mr. Faison's mental health conditions, including bipolar disorder that could cause psychosis, which you heard from Dr. Epstein, who's chief of psychiatry at Georgetown University, alongside his antisocial personality disorder with the propensity for deception, and that's from the government's own witness.
So I guess, how is it suppressed? How is it not turned over? Didn't it go to defense counsel at a time when they could then be included in their questioning?
It did not. The mental health record.
Sorry, I'm confusing this. Yes,
Sure.
too many issues in the case.
No, no worries.
They didn't have the records to turn them over. That was the question, right? And this actually gets to a point that I was discussing with my colleagues earlier, which is it seems like the trial court was sort of overreading the Vaughn case and saying we're going to kind of just ascribe ownership or possession of the U.S. Attorney's Office of materials that belong to an entirely different government agency and a different government, in fact. And so I guess I'm wondering first, how did the government have them to fail to turn them over?
Sure, and it's not our position that the government is required to turn over all documents that are in the possession of other arms of government like the DC jail. We think in this case, because the trial court rightly imputed possession on the prosecution in this case for a few reasons. I mean, first, the records were explicitly requested in a Brady request, including psychiatric records. Two, some of the records that weren't turned over had already been collected in Mr. Faison's own case, the Parker case. That also wasn't turned over in violation of Brady.
Let's stop there for a minute.
Sure.
If you clarify it for me. I was under the impression that those materials had been collected in the Parker McRae case by defense counsel, but were not in the actual possession of the government at the time your client was tried.
Your Honor, my understanding is that the records were known to the government. The government was familiar with the mental health records at the time of the Parker case. And it's our view that the government was certainly on notice that the documents existed. And we would argue that imputed into their possession by virtue of being familiar with the records as part of the Parker case.
And you're using some words I want to clarify.
Sure.
Are you saying the government had physical possession of them, or that it knew they existed and could have gone and obtained them?
It's our position that at that point, they had possession of at least some of the mental health records that had been collected and were part of the record in the Parker case.
We'll have to study the record more carefully, but go ahead with your argument.
Sure. And the third reason that I'll point out where I think it's important that the government should be deemed to have possession of these records is the fact that Mr. Faison had been tapped to testify in many other cases against many other defendants. He was a cooperating witness with the prosecution in multiple cases. Again, I think up to 25 defendants who he cooperated against.
Well, counsel, just to clarify that though,
Sure.
weren't the majority of those defendants split between just 2 or 3 cases and they were his co-defendants as opposed to completely separate, unrelated individuals that he met in the jail or in similar circumstances to hear?
That's correct. So many of the defendants were consolidated in the same cases, including his own case. I think there were at least 3 across the ultimately 25 defendants against whom he cooperated. But I guess my point is the government was calling him as a witness to testify about multiple confessions, including, as you've seen in the record, another copycat toilet bowl confession from the DC jail. And the fact that the government was relying on his testimony against so many other defendants, including Mr. Johnson, this impeachment evidence was even that more important for them to be aware of and for them to turn over under Brady.
Let's separate for the moment the mental health information from the evidence about cooperation.
Sure.
How do you deal with the Parker case, which related to much the same issue with the very same witness?
Your Honor, what I would say is that the Parker case was very different. When the mental health records were at issue in the Parker case, it was his competency to testify at his own trial. That was the issue.
No. You said that in your reply brief. And I read Parker and McRae very carefully.
Okay.
And they are both replete with references to the credibility of the witness at trial. So how do you distinguish Parker from your situation?
I would say that in this case, Mr. Faison was being put on the stand to testify about a confession that he allegedly heard, right? And so, and
Well,
was,
wait a minute.
sure,
In McCray and Parker, Faison pled guilty in the middle of trial.
yes.
He then became a witness for the government and testified against his former co-defendants. So how is that situation different than the situation here?
Your Honor, I would say first and foremost that in that case, it wasn't surrounding whether or not whether or not his auditory and his visual, he had any sort of impairment, right? I mean, our position is that he was impaired during the time period during which he allegedly heard this toilet bowl confession, that he was experiencing hallucinations in the same time period, that he had already been diagnosed with antisocial personality disorder. And our own expert, Dr. Epstein, provided evidence that Mr. Faison was likely going through some sort of psychosis at the time that he allegedly heard this toilet bowl confession. And I think that makes it quite distinguishable.
The trial court was not impressed with Dr. Epstein's testimony. Is it your position essentially that that's not her business? That's for the jury to evaluate?
That is our position. And Your Honor, I'll also note that the trial court also acknowledged that she would have let that evidence in. It would have been admissible had it come in at trial.
So help me with this. She said she would have let it in. She said that before this court issued the decision in Parker. And Parker said essentially that doesn't come in. So if she could have excluded it, said, I would not have let that in, why wouldn't Parker approve that decision?
Well, Your Honor, I also think it's different evidence. Of course, it's still based on the fact that Mr. Faison suffered from mental health issues. But here we're talking about an expert in psychiatry from Georgetown University who testified about, his view of those records, his understanding, his conclusions of his mental health issues.
You will help me more
Sure.
if you focus on the similarities and differences.
Okay.
In Parker, the question was whether the defense should have been allowed to hire an expert, or the court would appoint an expert who could look at the records and testify at trial about the mental status of Mr. Faison and how that would affect his credibility. That did not happen, and this court in Parker said it didn't need to happen because there is a strong presumption against presenting this kind of evidence at a trial, mental health evidence.
Sure.
So I will appreciate your help in understanding why Parker is different than this situation.
Well, another way that it's different, Your Honor, is that in Parker, it was not assessed under a materiality analysis under Brady. That wasn't the inquiry, that wasn't the standard that was applied. And so
I appreciate that. It was not strictly speaking a Brady issue, but our court said the jury didn't get to hear this evidence. It's okay that the jury did not hear this evidence. That strikes me as being practically the same thing as not material.
sure. And, I'll go back to the contrast, right? The record reveals mental health symptoms in this case, different from those in the Parker case, like auditory hallucinations, psychosis, repeated treatment with antipsychotic medications in the relevant time period when he allegedly heard the confession. I think on the record, this is a different situation with different facts, and it applied a different analysis.
It's a different situation, but Parker sort of relies on McCray and relevantly on page, I think it's 1151, the Parker frames the McCray inquiry, right, as whether appellants could show that Faison's mental disabilities seriously impacted his credibility by casting substantial doubt on his ability or willingness to tell the truth. That to me seems to be kind of akin to a materiality standard, right? It's not just that he might have had some sort of mental illness or defect, but that at the time it was going to seriously impact his credibility. So having this information essentially rises to the level of materiality. And so I don't know if that's Judge Fisher is concerned, but here it does seem to me that Parker, or at least informs our analysis of what the legal question is.
Sure. And again, I would just say that it is a different analysis, and under Brady, you know, and you know, one consideration when
Wouldn't you
you're,
have to show it would seriously impact his credibility for it to be material.
I think that, well, I mean, first of all, I think it did seriously impact his credibility in this particular case, perhaps compared to the Parker case. I mean, again, here, what we're talking about is a specific time period during which our own expert says he was hallucinating, he was experiencing psychosis, he was on lithium, he was on drugs that are used to treat psychosis at the same time that he claims that he heard this toilet bowl confession. Now, I'll also point out that in a materiality analysis, this was only one witness. I mean, putting aside the legal note, this was the witness that was saying that, you know, this guy confessed. It's some of the more important and most powerful, as this court has said, information against a criminal defendant that can come out at trial. And so the fact that it had to do with the only confession from an individual, putting aside the note, the fact that, you know, the mental health records substantiated that this guy was possibly hallucinating at the time when he allegedly heard the confession. I think all that together certainly means that, you know, this was material to Mr. Johnson's case, you know, and different from the Parker case. Unless there are any other questions on the Faison issue, I'll just quickly move on to the two remaining errors.
We already have you fairly significantly over time, so if you will do
Sure.
those expeditiously.
Sure. So in terms of the two final issues, the cell tower evidence, you know, it's our position, this is outlined in our brief, that Kagosi, this court's decision, is dispositive of that issue. The trial court found that failing to consult and much less retain an expert in this case was a strategic decision, and Kagosi says otherwise. Finally,
Let me ask you about the expert. As I understand the trial court's assessment of that, she was saying there were good reasons not to call an expert. And I understand what you meant by that was that the expert, all we have to work with is the affidavit of the after the trial expert, but that affidavit reveals that that expert, if cross-examined, would have said, yes, the cell tower data does place Mr. Johnson near the scene of the shooting at the time of the shooting. The question is, how close was he? That would not be good to have a defense expert essentially agreeing with the government expert. So why wasn't it a sensible decision not to run that risk?
well, and so I'll start with sort of the premise question, and this is where Kagosi comes in. As that case says, you can't make an assessment of whether or not to call an expert if you haven't done a reasonable investigation. And it's our position that the lack of a reasonable investigation in this case is dispositive. How would his trial counsel know what a cell tower expert could contribute, having not investigated it herself? And, you know, speaking to the government's expert, in our opinion, was not enough. In terms of
But they
what
didn't just speak to the government's expert, right? They spoke to the government's expert, and then they spoke to somebody affiliated with the cell phone company.
Yeah, it was just a custodian of record who did not provide any substantive analysis or other information, and actually encouraged trial counsel to go and find her own expert, which she did not. to your point about what an expert could have contributed to this case, while there are certain things that a defense side cell tower expert could not have disagreed with by the government's expert, there's a number of things which are outlined in Mr. Daniels' affidavit that he would have said had he been called at trial that could have raised reasonable doubt in the minds of the jury about how strong the cell tower evidence was, whether Mr. Johnson was likely at the scenes. And I can go through some of those, but I know you guys have the affidavit.
Well, it looked to me like all of those points were brought out in front of the jury, either by the government on direct examination or by defense counsel on cross-examination.
It's our position that there's 4 or 5 at least points that we've included in our brief that did not come out either through cross-examination of the government's expert or through direct examination. As one example, and this isn't in our brief, but the probability that Mr. Johnson's phone was present at the fight or crime scenes based solely on the cell records, he would have said that the chance is quite small. And that's in his affidavit at paragraphs 11 and 12. In addition, Mr. Daniels could have contributed to Mr. Johnson's case that his phone was in the purple coverage area far more often and on many more days than the government represented. And that's important because part of the government strategy was to say he was never in this area, he was never in this area. And oh, by the way, on this, during the crime at issue, he was in this area. And what Mr. Daniels would say is that's simply not true. And he was in it much more often. And so that was a critical part of their cell tower expert's testimony that could have been rebutted by Mr. Daniels or another cell tower expert. Now, finally, as to the testimony of Mr. Shores, and I'll be very brief. It was after jury selection, after opening statements, after the government had already started putting on witnesses that trial counsel learned for the very first time that Mr. Shores was a potential alternative suspect. And it was after Mr. Shores had already testified that the second police report was disclosed that showed him, potentially robbing the victims with video evidence supporting. That was critical information that had Mr. Johnson's trial counsel had access to that information in advance of trial. She could have developed a stronger defense theory. She could have presented to the jury that there is this other person that might have been an alternative suspect. There are many theories that could have been investigated, developed as to Mr. Shore's involvement that, the trial counsel was prevented from exploring because she was not aware of the 2 police reports that were turned over in the middle of trial. With that, unless the court has any additional questions, I'll save my 3 minutes for rebuttal.
Thank you, counsel. Counsel for the government.
Thank you, Your Honor. May it please the court, counsel, and Carol for the United States. Your Honor, Judge Leibowitz presided over a lengthy trial, presided over 6 hearings out of multiple versions of appellant's motions to vacate his convictions, and carefully analyzed both the facts and the evidence in this case, and found that the overwhelming in this case, to the extent that there was any additional evidence that appellant claimed that he could have had or could have used, would not have impacted the outcome in this case. And first, if I can just recite some of the evidence that was so overwhelming. First, on June 21st of 2011, appellant was in a park on 14th Street when Mr. Kennedy, Nicholas Kennedy, walked up to him to try and resolve an old beef from 2008. And as soon as he spoke to appellant punched him and the 2 had a fight. When Mr. Kennedy went back to his neighborhood on Spring Place, he found appellant there confronting one of the decedents in this case, Mr. Barber, and again tried to intervene and stop this fight. And what Mr. Kennedy said was before appellant left was appellant said, This ain't never gonna be over. A neighborhood teenager also testified at trial and corroborated that evidence. Video of the fight from the park also corroborated Mr. Kennedy's evidence. And Mr. Kennedy testified that a short time later, after appellant left, he returned and fired multiple gunshots at him and others near him in the neighborhood with an accomplice. And what police found were 10 millimeter shell casings, as well as 45 caliber shell casings and a 45 caliber weapon that had been discarded in appellant's and his companion's flight path.
That motive evidence might amount to more if Kennedy had been one of the people shot on July 9. And your opponent makes that point, that it wasn't retaliation against Kennedy.
But it wasn't about the fight. The whole issue was the neighborhood beef. In fact, what was excluded from the evidence, what the substance of the beef was that appellant was suspected by the Spring Place neighborhood, of which Barber and Thomas and Simmons were a part, of having robbed Barber's friend in 2008. Now, that piece of information was not disclosed to the jury, but what was disclosed was it was a neighborhood beef between Barber and Spring Place and Mr. Kennedy. And Mr. Kennedy was actually trying to quash the beef that was between Spring Place and appellant. And what the evidence also showed is less than 3 weeks later, on July 9th, Mr. Kennedy was not with Mr. Barber, Mr. Simmons, and Mr. Thomas, but that surveillance footage showed that from 14th Street, there was a camera that the three gentlemen entered the block at approximately 5:45 a.m. And I have to look up the exact time. But surveillance footage also showed a young man named Steve Harden, who happened to be a very close friend of appellant, riding his bicycle through that block, both before and in the immediate aftermath of the shooting. So what happened was within about 2 minutes after Simmons and Barber and Thomas enter the block, Mr. Harden is seen on video reacting to the gunfire and rushing away. And 26 seconds later, Mr. Shores is seen running the same direction as Mr. Harden, away from the gunfire. And what Mr. Harden testified was he had been riding through the block. He saw appellant, his good friend, standing near where the folks were gambling in the middle of Parkwood Place. And he was standing next to who he described as a brown-skinned dude with long dreads, which exactly matched Mr. Shores' description. And that corroborated both the fact that Mr. Shores was there and that appellant was there. And that after Mr. Harden saw Mr. Simmons, Barber, and Thomas walk into the block. And what Mr. Shores testified was that he did engage in a drug transaction with Mr. Barber in the street.
This sounds like a harmless error argument to me. Are you conceding there was
No,
error and that the overwhelming evidence makes it harmless? Why don't we talk about the allegations of error?
I will do that. I'm sorry, Your Honor. The reason I started with this is because appellant's first line of her argument was, or his argument was, that these were four errors that were the critical evidence in this case. I have not yet mentioned either Mr. Faison or this note or any cell tower evidence. And yet we have eyewitness testimony that places appellant at the crime scene. And Mr. Shores, the reason I was going into Mr. Shores' description of it is Mr. Shores' description was exactly corroborated by the physical evidence of the victim's injuries. The placement of the gunshots, the placement of the bodies, and the nature of their wounds was exactly consistent with what Mr. Shores testified had happened. I can start with, first of all, very briefly, Mr. Shores. Appellant waived any claim with respect to the drug report. First of all, at the point where they learned of this admission of a drug transaction, it was days before Mr. Shores testified. It was after opening statements. But before opening statements, pre-trial, defense counsel had already proffered a basis to go into potential drug evidence for impeachment purposes. And in that proffer,
The appellant doesn't really rely that heavily on Shores, at least in the
Okay.
presentation today, so I think
Okay.
I'd be really
Faison.
gratified if you could turn to Faison, yes.
okay,
thank you.
all right. With respect to Faison, first of all, as Your Honor correctly pointed out, we did not have any of his mental health records. None of them were in the government's possession, and therefore there was no suppression of evidence. With respect to,
And I mean, the government assumed, and obviously I have some skepticism of that, but I sort of assumed that they'd been suppressed and then went out of materiality. Do you think that we can touch the suppression claim now on appeal?
the court assumed without deciding. The court did not, the court actually gave the broadest view of appellant's arguments in order to reach the most significant factor, I think that was dispositive, and that was none of the claims that appellant raised would have changed the outcome of the trial. But with respect to the possession, again, Your Honor correctly pointed out that Vaughn, the court wasn't sure of an off-the-cuff comment at a hearing. She wasn't sure that it wouldn't be imputed based on Vaughn to us, but she assumed without deciding that fact in her order. And appellant even conceded it was not in our actual possession, mental health records. But more importantly, the court held multiple hearings at which Dr. Epstein and Dr. Patterson testified. Your Honor correctly pointed out that Dr. Epstein's testimony was simply not persuasive and would not have persuaded a jury, as Judge Leibowitz found. He took items out of context. He did not.
That's a pretty thrill-seeking position for a trial court to take. I don't believe the evidence, therefore the jury wouldn't have believed it.
In fact, Judge Leibowitz did not frame it in that way. What she did was she said there were many reasons because of course, Parker had not been decided. And so she assumed that this evidence would have come in. And so she analyzed it as if the jury had heard this evidence and would it have been persuasive? And what Judge Leibowitz found was there were many reasons not to have been persuaded by Dr. Epstein's testimony.
I wonder if you could clarify some facts about the mental health records. A very important document, it turned out, was a psychiatric examination of Faison that occurred way back when, in maybe 2009, 2006, I forget.
I believe that was Braden Manor.
Was that in the jail records? Or was that in juvenile court records
I believe
that could not be accessed through the jail?
I believe that would have only been juvenile court records, and that Your Honor is correct. That would not have been something that was in the government's possession. The defense, however, was familiar with Mr. Faison, having been formerly co-defendants of his, and was aware of, seeking Mr. Faison's juvenile court history. Judge Green had provided an order for defense counsel in McRae to obtain that information, that none of which was provided to the government, none of which was obtained by the government for good reason, because at the time that the defense sought to have a mental health examination of Mr. Faison, to hire an expert and have somebody examine him for potential cross-examination, Judge Green found that the document that the defense was referring to did not establish a reason to conduct that examination. Judge Green discredited whether or not it impaired Faison's credibility at the time he was testifying. And therefore, there was no reason for the government to go seek out additional information.
So I share Judge Fisher's concern that it seemed like the trial court was perhaps usurping the role of the jury or the function of the jury to assess whether they would be convinced by the evidence, even if she was not. And so it's also sort of an unusual situation where we have a history with Mr. Faison, right? We have McRae and Parker and this whole constellation of cases, but Parker came down after the trial court's ruling in this case, as I understand the chronology. So can we sort of rely on that now as a basis to affirm if we're sort of troubled by the actual reasoning that the trial court gave?
I think the actual reasoning the trial court gave was the short answer is yes. Your Honor can look at Judge Leibowitz's findings, and based on those findings, they were consistent with Judge Green's findings. That is, there was not evidence presented that substantially impaired substantially impaired
his credibility.
impaired his credibility, and therefore there shouldn't have been a basis to cross-examine him about mental health records. And that's based on this court's precedent, both in Parker as well as the cases cited in Parker for a long standing, that there has to be a substantial impact on the witness's credibility in order to invade the province of mental health history. And that was not established here based on the court's findings. The court, again, did not usurp the role of the jury, but couched it in explaining, one, Dr. Epstein had absolutely no familiarity with DC jail, had never met Mr. Faison, relied on records from DC jail that were taken out of context. And even in its articulation, Dr. Epstein did not opine about whether or not Mr. Faison was actually hallucinating. And the court also heard from Dr. Patterson, who explained that if you're going to have auditory or visual hallucinations, it's not going to be about somebody confessing to you in such detail as Mr. Faison provided. So the record that is before this court explicitly provides a basis to say that it's not material in this case because it would not have been admissible cross-examination. The evidence based on the mental health history.
Let's go through that again. What would not have been admissible cross-examination?
Based on the mental health history or the mental health records. Appellants, the majority of appellants' claim with respect to Faison boils down to the mental health records, the mental health
The
records.
trial court didn't say that. The trial court did not say it would have not been admitted.
No, the trial court did not. Again, because the court, one, did not have benefit of Your Honor's decision in Parker, but also because, and I would submit that Judge Leibowitz was carefully analyzing all of the arguments and evidence in the case and essentially moved on to materiality because it was so dispositive in this case.
So is Parker by itself enough to allow you to win on this issue? Or are you saying that we have to splice Parker with Judge Leibowitz's findings to let you win?
I think I would submit that I think Parker is dispositive because mental health, the appellant has not met its burden here to establish substantial that mental health records affected Mr. Faison's substantial credibility. If appellant had created a record that supported that it impacted his substantial credibility, then Parker would not necessarily be dispositive, but based on all of the evidence.
Ms. Branch said, essentially, we did create that record because here, unlike in McCrae and Parker, there was all this stuff about auditory hallucinations. And he wasn't hearing confessions through the toilet pipes. He was dreaming all this up. And we've got an expert witness to support that there were auditory hallucinations that led him to mistakenly think that Johnson had confessed.
I'd invite Your Honor to review Judge Leibowitz's findings as well as Dr. Epstein's actual testimony, because as Judge Leibowitz found, even in its articulation, Dr. Epstein did not say that that Faison was subject to auditory hallucinations. The way he couched it was, it might be possible that he was suffering from auditory hallucinations based on the things that he was saying. But again, at the time that he was relying exclusively on documentation and DC jail records. And Dr. Epstein took cherry picked those records for pieces of where the defendant was, excuse me, Mr. Faison was pretending to listen to somebody talking to him. And it was documented in the note by the DC jail employee that was with him. He's faking, he's pretending to do so. And even Dr. Epstein says, well, if he's saying to you he's faking, he probably is faking. And there were reasons for that. Each of the instances, as Judge Leibowitz went through, there was a reason why Mr. Faison was behaving. Either he was acting because of some desire to either get out of the hole or to see a doctor, to have some interaction because he was in the hole. There was an instance that Dr. Epstein relied upon when he was acting out after, expressing some distress. And what the record also reflects is that Mr. Faison was reacting to having learned that his mother was threatened at gunpoint. So what Dr. Epstein did was he took pieces of information out of the DC jail records and tried to draw a potential scenario under which Faison might have been hallucinating. And when under cross-examination and the court's findings, and after hearing Dr. Patterson, it was completely unsupported by the actual records themselves. And therefore, there was no record from which the court could conclude that the mental health, that Dr. Epstein's testimony would have caused one to find that Faison had a substantial impairment of credibility. It simply was not in his testimony was simply not that affirmative or that persuasive or that credible. Dr. Epstein, I speak of.
So just to put a finer point on this, you think that we can perhaps just resolve this on Parker McRae alone, but if not, you think that the grounds that Judge Leibowitz gave were sufficient on their own?
Yes, I believe Judge Leibowitz's factual findings in which she articulates the reasons why a jury would not credit Dr. Epstein provide the same basis under Parker where this would have been excluded. And that is an alternative way to resolve materiality. Judge Leibowitz resolved it based on the strength of the evidence and the fact that a jury would not have credited the auditory hallucination argument based on this detailed information that Mr. Faison provided. Again, even as Dr. Patterson explained, if you're going to have auditory hallucinations, it might be, oh, kill yourself, or, not, I committed this crime. I hid at my aunt's house in Lusby, Maryland, because the marshals would look for me at my mother's house in Florida. I'm worried about the cell site data that would put me at the scene of the crime. I shot somebody. I shot another guy so I wouldn't leave a witness. This type of information is not the subject of auditory hallucinations.
So I know you're out of time, but if our presiding judge would indulge me, I'd like to take you to the note for a bit.
Certainly.
Well, first, you seem to sort of reject the appellant's Rule 16 argument out of hand. And I guess I'm just trying to understand what role it plays. And I suppose I have a couple of some subparts. I mean, first, I think you sort of say, it's about pretrial discovery, so this doesn't matter. But this all sort of happened in a pretrial posture, correct?
It was a pretrial posture, but it wasn't turned over pursuant to Rule 16. And as the Supreme Court said in Nobles, it distinguished between Rule 16 and the privilege. The attorney-client or work product privilege may be encompassed within Rule 16, but that does not lay out the requirements for finding whether or not there is such a privilege. We have actually two responses to the note, if I may. One is, apart from whether or not appellant established a privilege with which we submit, neither privilege would have applied. But there was no reason for a trial counsel under Strickland to have believed that this was a privileged note based on her interactions with appellant, and based on the face of the note itself, as Your Honors recognized, as Judge Leibowitz recognized during trial. These weren't direct, these weren't questions for counsel. There was no question marks. There was no reference to PDS attorney Ms. Brown, who was his lawyer at the time. There was no indication that this was a document created for counsel. It is.
But the document was directly responsive to evidence in the case and things that came out. In a recent case that had come out to that point, in a recent case, Moore, that was released in 2022, we talked a lot about an inmate not readily having access to his counsel and the situation there. I think, why should notes that could potentially be used with counsel be classified otherwise?
In this case, Your Honor, and I'm glad Your Honor brought that point up, is appellant testified he made this note and made no effort to communicate it to counsel. He made no effort to reach counsel to set up a meeting. Even under the cases appellant cites, if you're going to qualify it as attorney-client communication, there should be some effort to actually communicate to the
That's
client.
right, but does that really excuse work product?
And if it's work product, even under appellant's cases, there should have been an effort to, if the client is writing something that is work product, it either has to be at the attorney's direction, or if it is something that I want to get to my attorney for use for my case. And again, the fact that defendant wrote the note and kept it in his cell, never shared it with his lawyer, never attempted to.
The note got taken
schedule-
away pretty quickly, didn't it?
He had said it was written between December 2nd and December 22nd. He did not meet with his attorneys until July 11th, and that was because his attorney, Ms. Brown, wanted to schedule a meeting with new co-counsel, Mr. Robbins. During that
Friend on the
time,
other side actually says that hurts you because you never know when you're going to be talking with your attorney, and you might want to, if you have my memory, write something down if it's not going to be 7 months until you get your attorney.
if he had wanted to communicate it with his counsel, he could have contacted PDS and asked for her to come and see him. And that was the point, is even in the cases that appellant cites, which are from outside of this jurisdiction, this court has never held a defendant's notes are work product. Outside of this jurisdiction, the only way it has been held to be work product is where it is immediately turned over to counsel for purposes of preparing the defense. There is no evidence in this record, and Judge Leibowitz found none, that the defendant wrote this note with a purpose to provide this information to his attorney.
So help me with this, because this just has a fundamental feeling of unfairness to me right now. Anytime a defendant who's incarcerated or just in the jail waiting wants to think on paper and not just memorize it or something of that nature, you're saying that they need to either immediately find a way to communicate that or make some proactive effort there, or destroy their notes, or it's kind of fair game. Is that right?
It depends on what the purpose of thinking through on paper. There could be any number of purposes. And all of the cases that have articulated both the communication and the work product privilege have focused on the intent of the defendant at the time. And Judge Leibowitz found and discredited appellant's testimony that he did not intend to communicate this information to his attorney when he wrote it. And he didn't intend it to be a work product. He wasn't told to create it as a work product. And in order for it to have a privilege to have applied, that finding is not in the record.
But was the note a confession?
No, I mean, Your Honor's,
But
I mean,
The
it might have
government
been-
characterized it that way.
in closing argument, it may have been characterized because of the use of the pronouns, but even as Your Honor has noted, if I suppose to be, and that was the one line of this note. If I suppose to be wearing hat and glasses, how could he recognize me? Even in its articulation is not a confession that it was me, I did it, I did the crime. That is not what this note was.
But
It
don't
wasn't
we have
that.
to take you on what you represented below?
Even assuming that it is a confession, and I say, even assuming that one line is a confession, that isn't necessarily dispositive because.
Well, let's not assume it's a confession. Let's say that below the prosecution said it was
Yes,
and pressed on that point repeatedly.
right. That does not, I would submit, given what the trial court found based on her viewing of the note itself. I mean, I have a copy of it. It's the tiniest of scribbles.
I mean, we have a lot of her view versus. the
It's
jury's
barely
view.
legible. It has list of potential government witnesses' names. There's not necessarily a reason why, I mean, it is not required, it was not required for Judge Leibowitz to find that a defendant facing a murder charge, writing down potential witnesses against him, would necessarily have intended to share that document with his attorney. And the government did not find, Judge Leibowitz found the only information on the note suggested was familiarity with the case. When Judge Leibowitz looked at it, it said it didn't appear to be directed at anybody. It didn't appear to be a question or otherwise a rhetorical question, other than a rhetorical question. And it did not, its significance was it reflected familiarity with the facts of the case.
So what was it reflected familiarity with the facts of the case? Is that really how it was used? Is that what its probative value was?
I agree with Your Honor that the government characterized this as a confession, and I do not back away from that. What I'm arguing, however, is Judge Leibowitz, both at the time of trial, had looked at the document and provided her evaluation of it. And after hearing 3 separate trial days of hearings on this particular issue, found that the document did not appear to be a note written for counsel, did not appear to be privileged work product. And there was no reason for, based on a defendant's behavior, there was no reason for his lawyers to have believed it was work product. I'd also point out 2 things. One, the PDS counsel provided all of the exhibit, all of the discovery to appellant. At no point did appellant ever pick out this piece of evidence and say, hey, I wrote this for you. At no point, even when Mr. Robbins had a conversation with appellant before trial about moving to suppress the evidence from the jail cell, did appellant say, oh, that was for you, I wrote that for you, because appellant said, in fact, in talking about the only basis to exclude it was privacy. It was an invasion of his privacy. Trial counsel, and I'd also point out, on February 13th of 2013, this piece of evidence was identified in front of by Detective King Watts, who had executed the search warrant. The next day, it was the next day, on February 14th of 2013, that appellant first wrote to Ms. Brown the note saying, I wrote that for you. It wasn't until the following day that appellant had an opportunity to reflect an additional basis to try and exclude it. In fact, Ms. Brown objected and moved to strike the note at that point based on attorney-client privilege, and very carefully worded her objection, saying, I learned this morning, Mr. Johnson wrote this note. He tells us this morning that he wrote this note for us, and asserted privilege. And Judge Leibowitz rightly responded, there's no reason to believe that it's privileged. There's nothing on the face of this document that indicates it's privileged.
Counsel, let me ask you, there's evidence in the record that Mr. Johnson would write himself a lot of notes, and that's how he would engage with his case. Could we just as easily believe he forgot about that particular note until his memory was refreshed after it and everything else he had been taken out of his cell at one point?
Well, that was my first point, Your Honor. The discovery was provided to the defendant in June of 2012. Every single piece of discovery was copied for the defendant. The defendant went through the discovery, went through the case with appellant's counsel, Ms. Brown and Mr. Robbins. It was 6 months later, in December of 2012, that Mr. Robbins consulted with appellant about moving to suppress the evidence from the jail cell. It wasn't until February 14th that appellant for the first time said, I wrote this note for you. I told you that. And Ms. Brown's reaction was, you didn't tell me that, and you want me to go along with this way to try and exclude, this alternative basis to exclude. And so she made the objection carefully, as she testified, articulating the basis that my client has told me today that he wrote that note for us. And based on those facts, one, the fact that the defendant allegedly wrote this note between December 2nd and 22nd, and at no point until February 14th of 2013 did he ever assert that that note that was turned over to him in June of 2012 was written for counsel. So neither counsel had any reason to move to exclude, and therefore there was no deficiency. And apart from the deficiency, as we argued in our brief, Judge Leibowitz carefully evaluated all of the evidence and found that it would not have made a difference in the totality of the evidence. I'm happy to touch briefly on the cell tower evidence if Your Honor has any questions on that.
Colleagues.
I would note that defense counsel's expert would have also placed appellant on the scene of each offense, and that Mr. Clark was not just a custodian, but had been certified as an expert in the same records that Mr. Torrisi testified about, and provided all the information that appellant's counsel could use to carefully and thoroughly cross-examine the government's expert. Without that, I would ask the courts to affirm appellant's convictions and uphold Judge Leibowitz's rulings.
Thank you, counsel. Ms. Branch.
Thank you, Your Honors. Just a few points in response to counsel's argument. On the phase-on issue, one question that was asked is whether the Parker decision is enough, whether Judge Green's decision is enough to be dispositive of the phase-on issue in this case. I pointed to a number of differences between the case. I'll just point to a couple more to support that it's not enough in this case. One is that in the Parker and McRae case, there wasn't a bipolar disorder diagnosis with psychosis. And in other words, the experts in that case reached a different conclusion than the experts in this case, which also distinguishes the Parker case. Also, another, I think, critical distinguishing factor about the Parker case is the fact that that case was about what Faison knew and saw about his own trial, right? So this is when he was cooperating with the government on a trial where he was originally a defendant. So that's another way that it's different. Now, counsel spent a lot of time discussing Judge Leibowitz's analysis of how persuasive she thought that Dr. Epstein's testimony was. And I'll just leave with the court that that's for the jury to decide, not for Judge Leibowitz to decide. And as I've already noted, and as the panel's already noted, Judge Leibowitz already said that she would have admitted the evidence from Dr. Epstein. Now, on to the note. Your Honor, you had asked before, so what? I think one point to keep in mind is on the prejudice point or materiality point, the government does not dispute prejudice. They don't mention it in their brief as to how the note was prejudiced, and counsel admitted just now that the government did in fact paint the note as a confession at trial and featured it prominently in their closing argument. Also on the note, and thinking about the principles of work product, there was a lot of talk about intent and what Mr. Johnson's intent was in writing the note and what evidence was available to establish that Mr. Johnson had written the note for the purpose of discussing his case with his counsel. I'll first say that from a work product standpoint, intent doesn't matter. It doesn't matter under a work product analysis what Mr. Johnson intended by the note.
That can't be true. Assume somebody who keeps a diary and says, I did the most thrilling thing today. He's sitting in his jail cell at the time he's thinking this. I did the most thrilling thing today. I shot 2 guys and killed them. I wounded a 3rd one. Boy, did I get a rush out of that. Dear diary, wait till I tell you what happens tomorrow. That's not work product.
I agree, Your Honor, that would not be work product. And I will say that in this case, it certainly wasn't a Dear Diary. My point about intent.
What distinguishes, you seem to be saying anything he writes about his case is work product, but you acknowledge my hypothetical. So what makes the distinction?
The distinction, Your Honor, is that the work product doctrine doesn't require that the note be written with the specific intent of discussing the contents with counsel. That's an attorney-client privilege argument. Here, as long as the note was written for purposes of Mr. Johnson's investigation, strategizing about his defense, at that point, it's protected under work product, and it doesn't matter whether or not Mr. Johnson intended to talk to his counsel about the questions that he outlined. Now, Putting aside that it's not
Well,
required
counsel
under a
helped
work.
me In
Sure.
Hickman and the Supreme Court in Ray Public Defender Service, our 2003 case, we talk about being in anticipation of litigation by or for the attorney. So even if he never intended to share that, how does that fade away? Like if it's by or for the attorney, how can he satisfy that standard if there was no intention to share it?
Certainly. And my point is just that the specific contents don't necessarily have to have been discussed subsequently with counsel and intended to be discussed subsequently with counsel under a work product analysis. Certainly Mr. Johnson, sharing at a later point how he was thinking about the case, how he was strategizing about his defense with his counsel is what you normally expect in cases like this and in any other case where you're facing trial. And so my point is merely that it's a different analysis, and a lot of the points that counsel brought up in terms of whether Mr. Johnson wrote the question specifically to cover with counsel don't matter under a work product analysis. But under an attorney-client privilege analysis, I will just assert that the record is strong that Mr. Johnson, in fact, did, raise the fact that these questions were taken from his jail cell with his counsel, and on numerous occasions flagged for his trial counsel that he had written questions for her and that they were seized. I'll just very quickly, we have the PDS log that was filled out shortly after the seizure where his trial counsel wrote, client cell was searched before holidays, his phone list and written questions he had for L. Brown. Those were the only written questions that were seized from his jail cell. And the PDS log supports that Mr. Johnson was flagging this issue for his trial counsel shortly after it happened. In addition, trial counsel's own notes that were taken contemporaneously with a meeting with Mr. Johnson also support that Mr. Johnson told Ms. Brown that, I had these notes seized from my jail cell.
But how do you square that with the facts that your friend on the other side gave about how this discovery was provided in June and, it was discussed about how to suppress and what to suppress, and it wasn't that this note came up until February?
Sure. And on that point, Your Honor, I would disagree with counsel's characterization. Mr. Johnson himself testified during the evidentiary hearing at this case that when he and his lawyers were going through the discovery together, he pulled it out and said, this is the note I was telling you about. And understanding Judge Leibowitz discredited essentially everything that Mr. Johnson said, that is what the record supports. Mr. Johnson indicated that he did in fact flag the note for his lawyer during when they were going through discovery together.
So
That's a credibility.
go ahead.
That's a credibility finding that it's really not for us to second guess.
Your Honor, I would say that particular factual finding from Judge Leibowitz was clearly erroneous, and that's part of our appeal.
Why?
It's our view that the record, if you look at it as a whole, certainly supports that Mr. Johnson flagged that he had written these notes for his lawyer and they were taken from his jail cell. And we disagree with Judge Leibowitz's decision to essentially discredit everything that Mr. Johnson said during the evidentiary hearing. Now, just the final point on the note, as counsel acknowledged during trial when the note was brought out, Mr. Johnson, and this is a document that we have in the record, this is not Mr. Johnson's testimony that Judge Leibowitz discredited. There is a document in our appellate record of Mr. Johnson writing a note to his counsel right when the note is introduced at trial that says, quote, "At time I wrote this note, and when they took it, I told you that I wrote it for you. I wrote it in response to the search warrant affidavit." Now, not to not give Mr. Johnson the credit that he deserves, but I can't imagine that note was written with the foresight of a DC 23-110 hearing on the horizon, but rather it is just further support that Mr. Johnson had told his trial counsel numerous times that this was a note that he wrote for purposes of his defense strategy for his lawyers.
It sounds to me like you're asking the three of us to credit what Mr. Johnson said and to disregard the credibility findings made by the trial judge.
Your Honor, it's our position that you don't need to. There is no reason why this court needs to disrupt the trial court's findings of fact at all, because we don't need the credibility findings from Judge Leibowitz in order to get us to work product and to get us to the first argument that we have on attorney-client privilege, which is that Judge Leibowitz agreed that there's evidence in the record that all of the subject matter that was within the original note was subsequently discussed with his trial counsel. And so those two pathways to privilege alone don't require this court to disrupt any factual findings. However, if we're talking about the third path, which is the Ed memoir, whether Mr. Johnson had the intent to discuss all of the questions and topics that were written down in the note with his trial counsel, we would assert that Judge Leibowitz's ruling was clearly erroneous on the facts. Because as I've outlined for you, there's plenty of evidence, documentary evidence in the record that supports that Mr. Johnson did in fact have the intent to discuss those topics with his lawyers.
Any further questions? Thank you, counsel. Thank you all for your oral arguments and your great briefs. The case is submitted.